Welcome to the 2021 California Property Tax Updates and Developments. The materials were sent via email and they will also be posted online if you would like to locate them later. Our program today is being co-sponsored by the Trust and Estate section, the Real Estate section, and the Tax section. The Trust and Estate section and the Elder Law Committee and all of its webinars are sponsored by the Sanborn team, Geffen Real Estate, Glen Escrow, and California Title Company. And today we are also being sponsored by Hochman, Salkin, Tosher, and Perez. And we thank everyone for sponsoring this program.
And Manufacturers Bank.
And Manufacturers Bank as well. Brian Joy from the Sanborn team and Orit Gadish from Geffen Real Estate are here to say a few words. And Nancy Sanborn as well.
Hi, everyone. It's hard to believe. I've been sponsoring the section of the estate section for 15 years. And as I was contemplating all of this, I was thinking it's been 1 year since we've met in person. Our last meeting was February of last year. But meanwhile, what I wanted to do was just reach out and to say what a great job I think Belinda, Genna, and Alex have done, along with the XCOM committee, of keeping everything going. You guys are terrific. And as always, this is a great program coming up. So thank you, and thank you for your continued support.
And now Orit Gadish from Geffen Real Estate will say a few words as well.
Hi, everyone. I'm Orit Gadish. I've been the broker and owner of Geffen Real Estate, commercial and residential brokerage for over 15 years. And we specialize in doing the right thing for our clients, for going the extra mile and doing whatever it takes to deliver the right solutions. If you'd like to connect with me to get to know each other, please text or call me. Back to you, Megan.
So we also have Marcine Klein as a full service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of estate act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. For Manufacturers Bank, simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estate banking team with the experience to handle all your banking needs. Contact Brian Flores, the Vice President and Senior Relationship Manager, for more information. Our next presentation will be on March 16th and will be with the probate judges. We will also present the Timothy Whitehouse Award. Now, David Shapiro will do the legal updates.
Thank you, Megan. The first case today is Copra v. Copra, Court of Appeals case C084032, 3rd District, filed December 12, 2020. After Frank Copra and Lucille, his wife, acquired a cabin on federal land in June Lake, Mono County, California, Frank and Lucille set up a trust that provided upon their death, the cabin would be distributed to their 3 children in equal shares to be held in subtrusts. After Frank's death, the estate was probated in Riverside County. Afterwards, the children attempted to renew the Forest Service permit for the cabin. However, the Forest Service informed them that they could only have one name on the permit. The siblings agreed to have Thomas Copra, one of the siblings, name on the permit. And the permit was renewed in Thomas's name. The other children contributed money for the upkeep. In 2015, 23 years later, The other siblings alleged that Thomas claimed that he owned the cabin outright and the permit exclusively, and that he was going to sell and keep all the proceeds, so they brought suit in Los Angeles County, where Thomas resided, as the principal place of administration of the trust. Thomas threatened to seek sanctions if his siblings did not dismiss the action and bring the petition in Mono County, where the cabin was located. When the siblings brought the claim in Mono County, Thomas demurred, stating that the Mono County court lacked jurisdiction and his siblings should have brought the action in Riverside County, where the state was probated, and the trial court dismissed the action without prejudice because it believed Riverside County was the proper venue. Thomas argued that his siblings' action should be dismissed because they did not bring a timely motion to change venue. The Court of Appeals reversed, holding that jurisdiction is statewide and not specific to any county. It was Thomas's responsibility to file the motion for a change of venue, and the Mono County Court held jurisdiction and erred by dismissing the action. No doubt, it's a wonderful cabin. The next case is Breslin v. Breslin, Court of Appeals case B301382, Second District, filed January 26, 2021. Don Kirshner died in 2018, leaving no wife or children but a trust. The portion of the trust listing the residual beneficiaries was lost. However, a document titled Estate Charities was found and listed 24 charities with handwritten notations that appeared to be percentages. David Breslin filed a petition in probate court, determined that he was the trustee and determined the beneficiaries. He served the 24 charities, but only 3 responded. The court ordered all charities to mediation, and one of the charities gave formal notice informing them that if they did not participate, they may forfeit their rights. Only 5 of the charities participated. They reached a settlement providing for the 5 charities that appeared, attorney fees, and the residual to the intestate heirs. Breslin filed a petition to confirm the settlement, and a charity that did not previously appear in the action or participate in the mediation objected to the petition to confirm the settlement. The trial court granted the petition to confirm the settlement, denying the objections without any evidentiary hearing because the charity had not appeared in the action and did not participate in the mediation. The appellate court found that the court had the authority to order the parties to mediation under probate code section 17206, and because the charity failed to respond to the mediation order, they waived the right to an evidentiary hearing on their objections to the settlement agreement. Now I turn it over to Joseph Goldman to introduce our esteemed speaker.
Thanks, David. And I will keep this short because, as you said, our speaker is indeed esteemed and needs no introduction. We figured, since everybody has been probably fed up talking about property taxes all year leading up to this Prop 19 deadline, we want to bring in the preeminent property tax expert around here to give you a little bit more and talk to you about where to go from here. So that person that I guess I've yet to name is Matthew Burke. We're very grateful that he's taken the time out of what I'm sure is an incredibly busy schedule, especially today, to do this presentation for all of us. So with just a little bit further ado, I will turn it over to him. The one other thing is, if you have any questions, we will try to get to them at the end. But if you do have questions, please leave them in the Q&A, not the chat box. The chat box will not be, Matthew will not have that open, but he might be able to get to them if they're in the Q&A. So thank you all again. Thank you, Matthew. And I turn it over to you.
Great. Thank you, everyone. Here we are on February 16th, and this was sort of, I guess, done kind of intentionally on my part to sort of push this off. It was originally scheduled now and I wanted to move it earlier, and I thought it was best to sort of wait till the dust settled on some of this stuff before talking to everyone. I subtitled my talk, Are We Having Fun Yet? Because I think that's probably the sentiment that we're all feeling right now between a year of being locked up and then this drastic change in the law in our field that has really turned many of our lives upside down and made us busier than we wanted to be over the last few months. So what I have today is kind of a truncated outline from what you would normally see me do in an annual talk. Normally I would have sort of a kind of comprehensive outline of all the subtopics that we talk about. And this year, we're just going to focus on kind of the implications of Prop 19, and some other and some Prop 8 stuff that I want to get to first. As you see, if you have the outline, I've attached to it. It's short, maybe 10, 11 pages. But what I've done is I've attached to it a bunch of exhibits. One is the actual ballot proposition language for Prop 19, Exhibit A. Exhibit B is a chart I just downloaded from the Board of Equalization website, which shows the comparisons of the old propositions and the new propositions as they apply to parent-child, wildfire, disaster relief, and base year value transfers. It's a little thin, but it just, it's a good place to start. The December letter to assessors from early December is Exhibit C. That's the BOE sort of first speaking out about Prop 19. Exhibit D is a bunch of forms they've come out with. These are in draft form. You'll see probably some of the instructions are not exactly in line with what the law really is or will be. And then Exhibit E is a legal memorandum from the Board of Equalization Legal Department to the Board of Equalization members with some Q&A that I'll refer to in the outline. But so to get started, the page 3 of the outline is my Prop 13 change ownership basic rules. This is the same thing you see in all of my outlines that I start with just as a foundation for people who are new to this. This is where to go to kind of get the basics of where the law is and kind of what Prop 13 does. I've used this over and over again. Note in paragraph I, there's a link here to the CPI adjustment schedule that comes out annually from the Board of Equalization that tells you what the inflation factor is every year. This year it's 1.036%. So it tells you how to multiply that here to get the adjusted base year value with the CPI adjustment. And if you go to that link right there, you'll see the historical inflation adjustments for all the years if you ever need to run calculations of escape assessments, which we do pretty often. So before we get into Prop 19 stuff, I want to just dispense with some Prop 8 talk. Proposition 8 allows for temporary reductions in a base year value when the market value of a property drops below its adjusted base year value. Obviously, COVID happening and there's a lot of distress in properties made everyone think that all of a sudden last year there would be reductions in their assessed values for the 2020 to 21 tax year because the tax year starts in July and all this distress was happening in March and April and May. But that's not how it works. And I think some of the assessors got a little ahead of their skis and started, talking, especially in LA County, and started talking about, we're going to be, getting everyone these reductions this year. But Prop 8 reductions are based on the fair market value of the January 1st prior to the July 1st. So as of January 1st, 2020, there wouldn't have been any distress quite yet. And so Prop 8 reductions are probably inappropriate for the 2020 to 21 tax year. Because LA County got a little ahead of its skis, they said, we'll still take informal requests from people, but we'll process them for 2021. So now we're in the proper time frame to start getting Prop 8 reductions for our clients for the 21 to 22 tax year, which starts July 1st this year. The way it works, if you remember back to 08, 9, 10, is that there is a mechanism for our clients and you to file for an informal request, which is just a piece of paper saying, I want a Prop 8 reduction. For commercial properties, you should attach an income and expense statement for 2020 and a projection for 2021 if it's available, just to show what the income is. It's only appropriate to get a Prop 8 reduction if the fair market value as of January 1st, 2021 is less than the adjusted base year value, the Prop 13 assessed value. So not everyone gets one. It's not just because there's a distressed market that you automatically get one. It actually has to drop below your assessed value. So it's only appropriate for probably more properties that were recently acquired or were inherited without a parent-child exclusion or something in the last few years. Assessors will do this proactively. Many of them do, as you know, from 08 to 13. LA County started doing them, and they were repeating them proactively every year. They don't, you don't have a right to that. So what I want to relay to people, a couple things. There's an informal mechanism, and then there's a formal mechanism. If you do the informal route and you request that the county give you a reduction. Every county has a different form for it. You don't have any right to an appeal. So if that gets rejected or the value reduction is not what you want it to be, your clients or you have to still file a formal appeal, which in LA County has to be filed between July 1st and November 30th. So the informal thing preserves absolutely no rights for you. If your clients filed last year thinking that it was, they could get it already, that appeal is bad because it's on a year-by-year basis. So that should be withdrawn and a new appeal should be filed this year. The AAB has no authority to roll them over, redate them, or anything like that. So don't think that your rights are preserved as to 2021 if something was filed last year. Don't expect to see any reductions on residential. I don't think the market has really panned out in that way that those would be granted. There may be some pockets in the state where they are, but certainly not LA County. For an informal request, you don't have to have a formal appeal done. Certainly for the formal appraisal. So just a quick and dirty income and expense capitalization would be appropriate just to run the numbers and see what it comes out to. Let's see. I think the biggest thing I want to talk about is my bold stuff on page 5 of the outline. And this is intentionally done in bold and italics. And this is about valuation reduction firms. It looks like I'm trying to put them out of business here, and I'm doing my best. You'll see these firms, you've seen them before, they come out of the woodwork and they start flooding you and your clients with mailers saying that they can get you property tax reductions. Please do not hire these firms. If they're hired at all, they should be hired with very, very, very strict negotiation over the terms of the contracts. What their contracts do is they very broadly say, hey, you're hiring us to do an informal request and then a formal appeal if necessary. And you're going to pay us a third or 40% or whatever their fees are. And then they throw this piece of paper out there that's their informal request. They have very low level clerks, very, lowly paid clerks who do those. And it's really just about papering the assessment appeals board with lots of appeals and to see what sticks. They don't put any effort into this stuff. And because the contracts say that you owe them a contingency fee, whether it's they get a reduction on the informal request or a formal appeal, they're really just about, a numbers game. And then often when, unless it's a really large property with a lot of money at stake, because it's only a 1-year adjustment on which they're going to base their fee, they'll often bail when it comes time to do the formal appeal. And if you go to someone else or try to hire an attorney, you're bound to pay them fees anyway. So all I can say is, buyer beware on these things. Their contracts are terrible. Just don't do it. Don't let your clients do it. You can't get out of the contracts when they're signed. They're just terrible, and they litigate to death to grab fees. If you or your clients have any doubt about a company, just privately email me. I can give you my thoughts about them. When it comes time to the formal appeals, certainly I think that they can be hired just starting at that time if you think that they're going to do the actual work. But certainly if it's just an informal appeal that they're going to do, maybe you pay them an hourly fee. On the informal appeals, not the informal appeal, but the informal request, that's just something that your clients can do on their own. You can do on their own. You can pay a paralegal to do that. It's just filling out a form with a request for a lower amount. So that's, enough said about that. I can't say enough about the issue I see is that if your clients don't use attorneys, there are no ethical obligations anymore. And so when it comes time to actually, disputing something, these guys will bail. They'll say, oh, you don't have a case, whatever. They just don't want to put the effort in if it doesn't look like there's enough money. And, an attorney has an ethical obligation to carry things through in the same way. So just don't do it. Okay, so over to page 6 of the outline on Prop 19. So what happened? So starting today, Props 58 and 193 are eliminated. Prop 58 is the parent-child exclusion we've had since 1986, and Prop 193 is the grandparent-grandchild exclusion we've had since 1996. And so those are eliminated entirely. As to transfers that occur on today and later. There was some board guidance we'll talk about in a second that indicates that transfers made and signed and notarized today would still be included in Prop 8 because the termination date of February 15th is a federal holiday, and I'm not sure. I mean, I think it's a great analysis, at least, but I wouldn't rely on that. Certainly, there's no harm in trying, but that's based on the DOE's legal opinion, and I could certainly see some counties pushing back on that. So what happened here? So I was warning all of you for a long time about this. I think not enough people were listening, perhaps, but I saw this coming, and here we are. So as we know it, the parent-child exclusion, the grandparent-grandchild exclusion are gone. As to the unlimited number of principal residences and the $1 million of other property. I think many attorneys, I found out, didn't understand in the ballot language that it was going to eliminate the $1 million of other property. They just thought that it was tightening up the principal residence rules. But in fact, as we've all come to learn now, it completely replaced Prop 58 in its entirety. So what we're left now with are some not so valuable rules as to principal residences and family farms, which I'll talk about in a second, because it's a pretty big part of my practice and for many of you out there in California. And then we've got new base year value transfer rules and some disaster relief rules, which are really kind of the same. So just to sort of back up a little bit, one thing I want to talk about is that obviously we're all a little surprised by how this shook out, because I think many people didn't realize what they were voting for when they voted for Prop 19, because it was packaged obviously as a benefit on the base year value transfer rules. And this was a rehash of the ballot proposition from 2018, where similarly that failed. And the California Realtors Association thought that they could get this passed and get some progressive support behind it if they had some teeth, so they could give something out, the benefit for those 55 and older, and then have some teeth and pull something back to sort of pay for it. And that's the loss of the parent-child exclusion. And as you've all read the language about trust fund heirs and East Coasters and stuff in it, that's where that all comes from. So I note that, and I'll get to this at the end of the talk about where do we go from here, but I note that when Prop 58 passed, it had 75.7% of the state or the voters were in favor of it. So it was not, maybe times have changed since 1986, but it certainly was favored by the voters. And in terms of old, I get this all the time, I think everyone probably knows it by now, but in terms of old transfers and deaths, certainly any death that occurred before today is under the Prop 58 regime. It doesn't matter when the trust or an estate is administered. It can be administered 5-10 years from now. We do a lot in our practice, cleaning up trust administration from 5, 10, 15 years ago. And any of those will be under the old Prop 58 rules, because the rules are pretty clear that it's the date of death that's the date of transfer, regardless of when it's administered. So to that point, at the bottom of page 6, we have these rules about parent-child exclusion claims. They're in 63.1 in subdivision E. That's the 3-year rule. And the way it's written is that to claim a parent-child exclusion or grandparent-grandchild exclusion, the claim form is due within 3 years of the date of the transfer, or before the earlier of 3 years from data transfer, or before it's transferred to a third party, which includes anyone except for other parents or children. And but there's always this out, and the out is that you're still timely if you file within 6 months of the date of a notice of supplemental assessment. And this is what's kind of given us an out for a lot of these old trust administrations. So someone can come to me with a trust that's was never administered in 1998. We see a lot of ones from 2009, whatever. And so long as the county doesn't know about the deaths and the transfers, I can file timely parent-child exclusions right now. So I expect that these provisions in 63.1E will continue. I would have a real problem if the legislature changed these, because there's no filing requirement in Prop 58 in the first place. I think the courts have held in similar situations that where a constitutional provision doesn't require a claim be made to reap its benefits, the legislature can make reasonable rules. But in this case, I don't think they can take them away. I expect that these will be changed, but probably just say with respect to transfers that happened in this time frame, here are the rules, and they'll come up with some different rules for transfers that are made under the Prop 19 regime. So I trust you've all done your work over the last few months. I don't know that I'm going to say much here that it will give you comfort as to what you've done. I don't, kind of want to get into what's a good parent-child transfer that occurred, before now. I think one general thing I will note is that I think many people were thinking of these rules a little upside down, in the sense that, everyone was so concerned about making a transfer that's a good transfer for change in ownership purposes, so they could get the parent-child exclusion, before today. And so they wanted to do things that were a change in ownership, and thought that the counties would not recognize certain transfers as change in ownership. But you have to remember that the counties are coming from things in the same vein. They're looking for changes in ownership. So, they're not looking to deny things as not being a good transfer. That's not to say that everything that you did is going to be viewed by them as being a good transfer, but they've never been in the business of trying to not find changes in ownership, because that's what they're trained to do. But trying to, they're there to find changes in ownership. And if you have an exclusion, you've got to claim it and tell them why a transfer is not a change in ownership. So just think about, maybe that takes some of the pressure off what you've done. They're typically not looking to say things are not changes in ownership that are recorded transfers. So now over to, what does Prop 19 do? Obviously, we've all read it by now. I criticize it for some of the defined terms are sloppy. So I've got a little snarky in here a couple of times about the drafters using the word taxable value, which we've never really used before in property tax, and all it really means here is the adjusted base value of a property. But things like that get very confusing. So what we're left now with is this rule that says that the parent-child, you can have a parent-child or grandparent-grandchild transfer, the grandparent-grandchild being under the same restrictions as before, with the middle generation being deceased, of a family home, again, that new defined term, basically just the principal residence of the parents, and quote, if the property continues as the family home of the transferee. The BOE has come out and said that it's their interpretation that the home does not have to be the family home of all the transferees. So a transfer could be made, to multiple children, so long as one of the children makes it their home. And again, family home just means it's their principal residence. Family being that it's, a parent to a child. It kind of means nothing more. And so long as one of the children moves in, makes it their primary residence, it should be qualifying, so long as all of the transferees qualify. So for example, you could make a transfer that was 1/3 to a child and 2/3 to non-qualifying grandchildren, and have it qualify. I think that's where they were going. Obviously, the legislature is going to have to make a lot of rules around this, and as far as I know, nothing. I've heard that there were efforts, but I've not seen anything. Maybe someone else has seen something. I expect a lot of the definitional sections in the rules will stay the same. So when you go to 63.1 in the Revenue and Taxation Code, the definitions of children and grandchildren, et cetera, should stay the same. So we got a couple things I'll talk about the value in a second, but I want to talk about farms before that. I do a fair amount of agriculture work. Probably many of you in LA don't. I know we've got people on here statewide, so we probably have some clients or some attorneys who do a lot of ag work. And what was added to this was the idea of a family farm. And so a family farm also gets the benefit of the exclusion and also with the same dollar amount. But the question here is, what is a family farm? It's defined as, this property which is under cultivation, under the government code. So we get that. We all know what a farm is when we see it. But the question is, what is the farm? Is it a parcel? Is it a single APN? Is it the appraisal unit? The appraisal unit is a property tax concept that looks to identify a property as to what would sell on the open market. So like a shopping center that would have a bunch of different APNs inside of it that was one mall would be a single appraisal unit. And you would see the same thing with a lot of commercial properties. So the idea here is what is the family farm? Early on, the BOE came out and said that it required that there be a residence on there as well, which sort of would have answered that for us, but there's no indication in the language that a residence is required to be on it. And so they backed off that interpretation. But here's where the real rub is. So the Prop 19 limits the value of the benefit to $1 million of fair market value. So we're on something very different here. We're not talking about $1 million of assessed value, which we could play with before. $1 million of assessed value before could have a $10 million assessed value implication in the resulting reassessment. We're just talking about a reduction of $1 million in the assessed value. And if you read the definition, if you read the value calculation in the ballot, it's very complicated. And all it's saying is what I have here in paragraph D. The new base year value is the greater of the old value or fair market value minus $1 million. So if the old assessed value is $300,000 and the fair market value today is $2 million, then it's 2 million minus $1 million. It's $1 million. It's just that simple. Maybe 30 words instead of 100 words in the definitional section. So we're left with a lot of questions. How do we deal with transfers of fractional interests on these? It's maybe more interesting on the farm question, just because farms are typically gifted in fractional interest over a long period of time. Certainly with residences, you can see that. What do you do when you've got a surviving spouse who wants to give half of a home to a child? The child moves in, and then how do you play with the rest of the stuff? We do have 62.3, which I don't talk about here, but that's still always there for certain transfers as well. But do you get, is it $500,000 benefit if one of the spouses is still there, or does there have to be everything and the $1 million all at once? So we'll see what the legislature comes up with on that. The transferee has to claim this is the claim requirement in the language is that the transferee must claim the homeowners or disabled veterans exemption at the time of the purchaser transfer or within 1 year from the date of the purchaser transfer. This is understood to mean that the transferee has to make the principal residence within a year of the transfer. Query whether or not a late claim gives them prospective relief. Again, there's some case law in the context of Prop 3 transfers, which are eminent domain transfers, base year value transfers. There's case law there that suggests that a late claim always gives prospective relief. So we'll see what happens there. There's no indication here that the same Prop 58 claim forms have to be made to the county, but certainly I expect that the legislature will require them, just as it does under 63.1E for Prop 58. And in fact, the BOE has come out with a draft claim form already, which just looks like the last one. Over onto page 8, as I've said here, paragraph G, BOE says only one child has to make it their principal residence. H, same thing I said before about transfers that would happen that would be notarized today. And but more importantly, I think is this question in I, which is whether or not the transferee has to continuously reside in the house to keep the benefit. And the ballot language, so the constitutional language now says that the child has to, in order to qualify, is if the property continues as the family home of the transferee. And so a question was asked in the Q&A of this BOE legal opinion, which is attached as Exhibit E. What happens when that child stops residing in the residence? And the BOE legal department said the exclusion applies only as long as the transferee or another transferee maintains the property as his or her family home. So the suggestion there is that once the property is no longer their principal residence, that something happens. And I guess the suggestion is that the base year value then reverts to the $1 million gets popped back on. But I question whether or not this would be lawful. If this is our actual position, the legislature would have to come up with language that says that this is a change in ownership, because the foundations of Prop 13 is that the base year value cannot be increased except upon a change in ownership or the completion of new construction. So I don't really see where this goes. It would be very odd and interesting to see the legislature come up with a rule that says that once the transferee is no longer living in the home as their principal residence, that there's a change in ownership. I don't know, it's going to be a good litigation case. So we'll see what happens there. I suspect there's going to have to be some sort of time frame, maybe put in the statutes. But I just don't see this being a forever thing, because I just don't see how mechanically the base year value could increase upon the termination of that. And obviously, we know all from a reporting position what happens. And I'll talk about that reporting and fraud and stuff at the end of this, because I think that Prop 19 puts a big spotlight on all that. So again, Prop 19, lots of open questions. We'll see what the legislature does. The claim forms are in that package. Those claim forms that are in the package that's Exhibit D to the materials, those are created by the BOE. Then it goes through an interested party process, and then they get adopted by the counties. So the counties will come up with their own forms eventually. Over onto page 9, base year value transfers. These are this was really the genesis of Prop 19. This is really what the California Realtors Association was looking for. They really wanted to see more churn in high-end real estate for those over 55 who were not selling because they felt locked in their homes. And as we all know, Props 60 and 90 that we had before were very onerous. So Proposition 60 was the first set of rules that allowed for those 55 and older to sell their home and to buy a replacement home, which is called replacement dwelling in the statutes and then in the Constitution. If the replacement dwelling was of equal or lesser value, and I think the Constitution actually says it's not not more. And so if Prop 60 allowed it just for within one county, and then Proposition 90 was adopted by through ballot initiative, and that allows for intra-county sales and purchases, but only if the counties agreed to participate. We only had 10 counties in the state that were participating in that, and they were all kind of nestled together in certain geographic zones. Not in you didn't have to stay in those zones, but they typically were like, big one would be Santa Clara and San Mateo. And then there were these onerous value tests for equal lesser value. So we always would see our clients would want to size up, and that really wasn't the idea. The idea was this was for seniors to downsize. And if the value test was blown, then there was no benefit at all. The value test was if you bought the replacement dwelling before you sold your original property, it could be it had to be no greater fair market value. If you bought the replacement dwelling the first year after, you could spend up to 105% and then 110% in the second year. And this was a fair market value to fair market value test, not a sales to sales price. So the counties would often game that by adjusting sales prices for things around the edges and deny claims. It's always been kind of a disaster. So now the equal lesser value test is gone, and expect that this will be a big boom for it's a great benefit for Californians and for older Californians who want to move, and it's a great benefit to the California Realtors Association who wanted this. What the rule now says is that transfers under Prop 19, that if the replacement property is of greater fair market value than the original property, that delta gets added on in full. So if you sold a house that was worth $1 million and you had an assessed value of $200,000 and you bought a new house for $2 million, then that delta of $1 million would get added on to the $200,000 base year value, and you'd get a $1.2 million base year value. So they can now upsize, and they can go anywhere in the state. The other benefit to this is that under Prop 1690, it was a one-time benefit, and it would also use the claim if there was a married couple who were both on title. So husband and wife on title, even if one of them was not 55, if they were on title, then their claim was deemed to be used. So you'd often have to take one off title when you sold it, and then buy the new property, and then put the other one back on title, just so the second spouse would use their claim. And now it's a 3 claim per person benefit, and a benefit under Prop 60 or 90 is not counted against this. So it's 3 per person, and you could basically just keep, hopefully you're not buying that many houses after 55, just keep going, selling and buying and selling, buying and selling. So this is really, I think, going to spur a lot of activity, and so your clients are going to come to you obviously with a lot of questions. And the scary part about, to me, I think the scary part about advising in this area has always been on the equal or lesser value test, because the questions I would always get from people is, well, what if I give them money back, or what if we put this in the sales agreement? Everyone was always trying to skirt the rules around what it meant to have a fair market value to fair market value test. And they'd want to call me and chat for 10 minutes and have me opine on their crazy schemes. So thank God that's sort of all done. One thing that they, obviously there will still be issues as to, what the fair market value and fair market value are, because it's still possible that there are battles over what the fair market value of either property are. It shouldn't be, if there's no arm's length sales, really shouldn't be that unclear, but that on the replacement property, it can be newly constructed as well. So that new construction has to be completed within 2-year time frame. And there can be, battles over what that, the new construction value is, because obviously our clients are not going to pay taxes on the full fair market value of the new construction, because they're going to get a base value transfer. But it's that delta between what they sold and their new construction that is what's going to get added to the assessed value. So, everyone keep their eyes out on those. Obviously, those are things that have to be appealed within the 60-day window of a notice of a supplemental assessment on the construction. If that window goes, it's typically the value can't be appealed because it's on a supplemental assessment. So, I expect to see a lot of battles over those sort of things, and clients who are, they're not noticing the bills that come in because they're busy and just, it's new construction. So there's this question as to whether or not on the April 1st operative date, whether or not the purchase or sale has to happen after April 1st to get in the new Prop 19 regime. And in December, the Board of Equalization came out with guidance where they said, it's not clear. I think rightfully stating so. And then this legal memo came out in early January, which is Exhibit E in the materials, surprisingly said that neither the sale of the original property or the purchase or completion of new construction of the replacement property had to occur before April 1st. And that older transactions could get pulled in. And they said, no, this is in paragraph F on page 9. No, the operative requirement is that the transfer of the base year value must be on or after April 1st, 2021, and not the purchase or sale of either the original or replacement property, which seemed a very liberal interpretation. And not quite sure where they were going with that. But then if you look at their comparison chart, which is in the Exhibit B in the materials, in the Q&A 2, the BOE says that either one or the other has to occur after April 1st. So we'll see how that works out. I just don't think we can advise our clients on that right now. It seems like you could rely on this BOE opinion, but it's not clear what the legislature is going to do. So I wouldn't have any clients, just close transactions right now. I would try to push anything off after April 1st if they needed to get one leg of the transaction after April 1st. I've had people call me and ask me what to do, and I've told them, just if it's a purchase, just ask the seller to for some extension or pay them for an option extension or something like that. There's other ways to figure that out. I think the key here is to pay attention to what the rules are. 69.5 is a very, very long statute. It's the base value transfer statute. It won't all stay because the equal or lesser value test is going to come out, but I think a lot of it will stay. And the rules are very, very rigid. And I think as we're going to see more of this, our clients are going to ask us more about it. It just was so infrequent before because people wasn't really used as much as people wanted to be. The calls were sporadic, and you guys probably all felt a little insecure about answering questions. And for me, I didn't take a lot of matters on because there really wasn't work around it. It was just these people that usually wanted to game the values, and it wasn't really a project there for me. But I suspect we're going to have a lot more work around it on the compliance and you guys can help your clients. But make sure that you understand these cases, and they're at the top of page 10. The Wunderlich case, not sure quite exactly how this was going to fit in the new scheme, but in this case, they said that land that was previously owned by the claimant, they built a replacement house across the street from their original house, and they had owned the land for a long time. And they tried to argue that the land, old base year value, was what should be used in the equal or lesser value test. And the Court of Appeals said, no, that's the whole fair market value of the property when you're done constructing your new house on it. And so, just make sure that everyone knows that that's what's going to happen in these fair market value tests. It's going to be, the difference is the fair market value to fair market value, and there'll be a full fair market value calculation done on both ends to figure out what increase there might be over the old base year value that's being transferred. And Groton House, which is the Groton House case, is I think the more important one to note here. In this case, the claimant sold his original property that was owned by an S corp and bought a replacement property in S corp, and his claim was denied by Santa Barbara County. And they said that your corporation, even though it's solely owned by you, is not an appropriate claimant because it is not a person age 55 and older, and your property does not qualify for the homeowner's exemption when it's owned by a corporation. And he made all these arguments as to alter ego theories and et cetera. So very important to not take title in anything other than client's name or trust with their name. Trust doesn't have to name on it, but it has to be obviously for their benefit. But no partnerships, no LLCs, and on either end of the equation. There was a case recently, I can't remember the name, where a guy up north, unreported decision, was successful, where he had title taken in an LLC, I think on the purchase side, but it was really just for a momentary blip in time where they were holding for financing purposes and then transferred to him. But just don't rely on that. And just be very careful in how your clients hold and a title when engaging in these. And then, so I think that's it on those. The disaster relief, I don't think we want to talk too much about here. I think the disaster relief rules on the BOE website are excellent. There's a bunch of different sections that apply. What Prop 19 did was it pulled in, this was so transparent for, in order to get this thing passed, they wanted, wildfire, disaster, and the titling, we all saw that. And so they now have the same rules for transfers of 55 and older for victims of wildfire or natural disasters that will effectively replace the old rules that are in section 69 and 69.3. It's not clear that those provisions were written out of the Constitution. There's a little questioning in the BOE materials as to what to do with those schemes. BOE seems to think that those schemes were intended to be removed. So we'll see what happens with that. I also note that that severely disabled is also a category for the base year value transfers along with age 55 and older. So there are other provisions in the 69 sections that deal with those who are severely disabled who can take advantage of these. And again, with unlimited numbers, as there were limits before on those. So I want to, before we sort of talk about a little, take some questions and go into sort of what's next, I just want to talk quickly about joint tenancies. I hope you guys didn't use joint tenancies to plan any of your Prop 19 planning. I know some of you probably did, but I hope you didn't. The joint tenancy rules are notoriously gamed in step transaction things. The counties are wise to it. They see it. They have people on staff who just do joint tenancies, so they're going to flag stuff. There may be things that technically worked, but if you thought that you were creating original transfer status and what you were doing, I suspect that position might not be successful later. So, the joint tenancy rules are intended to have a deferral of a change in ownership until someone's death later. The reason they're set up that way is that the legislature and the BOE early in Prop 13 viewed joint tenancies as a will substitute, so that you can put someone's name on title and nothing really happens. There's really no transfer to them right now. Because they're just sitting there waiting to inherit the property later. And then when the original person dies, it pops and they inherit it. We'll get the change in ownership later. And then there's this example 4 in the regs that says that, if A and B own property as tenants in common, they can transfer it to themselves to create a joint tenancy, and that they are original transfers. And this is where I think we're trying to go to create original transfer status for children, so that when parents die and the children inherit the property, that there's no reassessment. But I think this is really a step transaction problem, and it's hard to sort of see where it is in the rules. But if you look at example 17, we're over on page 11 in the materials. There's an example in 17 that deals with third parties trying to create original transfer status with the reciprocal trust, when the reciprocal trust rules were around between 2004 and 2013. And it's the same idea. The idea is, do you bring people on title in a way that doesn't cause a reassessment or a fractional reassessment, and then everyone creates a joint tenancy together to create original transfer status, and then the original people drop off. And so take a look at my notes there on page 11 about that. I think it's really problematic to make a small transfer to a child of a percent, or even the 50%, but a small percentage, and then say, well, now the parents and the children are tenants in common. We're going to create a joint tenancy and create original transfer status. So we'll see what happens when those all start being reviewed. If you have any of those right now that you haven't reported yet, I would think about that again. So where do we go from here? And I'll take a couple questions. There are efforts to reverse the effects of Prop 19 on Props 58 and 193. Howard Jarvis is talking to the legislature. I have told various groups that I would be willing to write the language and spearhead, the nonprofit. But I'm a little concerned about Howard Jarvis, and it's has a bit of a. I think they're all great people there, but sometimes there's a bit of a taint in things that they're on for property tax purposes. So people look at it a little skeptically. But we'll see where that goes. I think there's good basis for it. Obviously, there was support for these when they first were passed. I think we will see an acceleration of using the entity rules. So, in terms of where do we really go from here, I think I would recommend that you really get a hold of your clients' entities and start thinking about what you can do more aggressively there, especially where there are no original co-owners. Your clients may have many entities where there are no original co-owners, and those can certainly pass freely, to any number of generations without reassessment, so long as there's not a change of control. So really get your hands around those. Those rules could change, in the next few years. So I'd really, operate on those as that being kind of a priority of things to move that that we can move. I think the in and out of the entity stuff, getting some questions here about the sort of the in and out of the entity planning, that all, the way it's written in the uncodified language of legislative intent, that all depends upon a qualifying parent-child transfer on the outside of the entity. So obviously everyone's going to, keep trying to do those similar sorts of things without that qualifying transfer. We'll see where that goes. Maybe it's just about coming out of entities and being tenants in common for a while and going back into entities, but really about sort of maximizing what's there. Because I think the last free pass transfer is your free 50% on an entity. And then, we'll see everyone pushing the envelope, pushing it and pushing it and pushing it. So there'll be an acceleration of things that are potentially view to step transactions. And we'll have to go back to all of our step transaction case law. It's there. The counties see it. What they pick up, who knows? All the counties are different in terms of their sophistication level and what they're going to grab and fold together. So, that's, I think the next move is really going to be about, what can we do there? And then we're going to have certainly a lot of problems with non-reporting deaths. And obviously where the parent-child exclusion is no longer going to be available, you can have properties that are sitting in trust and there's going to be no desire or willingness to report the deaths of parent trustees. And so that trust administration is going to get very difficult. And my warning to everyone is that trustees can eventually become personally responsible for property taxes. And it works its way through the code that that's the case. So trustees need to be vigilant about making sure that they know what escape assessments and supplemental assessments are out there, what they're going to be, reserving enough cash for them. You don't want to see, I get this with trustee clients all the time where they've got all these beneficiaries yelling at them for cash, but it may be a year or 2 or 3 where they really know what the liability is going to be on those escape assessments. And especially in smaller estates where the trustees are the children, because they're not sophisticated enough to know that they need to do this. They think, well, we're going to sell these properties. So if we're going to sell them, then we're just going to cash out and we'll be left alone. But between the date of death and the date of sale, there could be a pretty significant supplemental assessment as a result of the death that triggers huge bills, and they may not come out for years. And I've seen too many cases where they come out and they're coming out in the name of one child who's a trustee and the cash is gone. And that ends up being a personal liability of the trustee, go on their credit report. It's a disaster. It happens far too often to really nice people. And it's very sad. And it is, it's fixable if it's something that happened, in Prop 58 world. We've still got that 6-month thing, but often they've blown the 6-month rule in now. Certainly after Prop 58 sunsets, we're in a situation where there are going to be reassessments on these properties before they sell them, and everyone needs to be aware of that and act appropriately. Let me go to some questions now. What's my opinion of it being found unconstitutional? I don't think it will be. I think it could be repealed by a future ballot measure. I think that's where everyone's sort of going right now. I think if it were just limited to the ballot issue were written in a way that just says, hey, the public was snowed about the parent-child stuff, and so we want to reverse on that. I think if the right backing to it, I think it could happen, because certainly everyone was snowed about it. It was not in the titles, and it was pretty buried. Even a lot of these sophisticated lawyers didn't know what was really happening in it. That one's question. I think you're all I answered a lot of these. I think on the multiple step stuff about kind of going into an entity, transferring, coming out, going back into a new one. We're in step transaction land, guys. So whether or not this is stuff that happens over a long period of time that can get around that is just like anyone's game. I know of people who've done that without the intervening parent-child transfer in many counties. They've just sort of washed these partnerships and LLCs over and over again without doing those tick transfers, and they get away with it in some counties. But just expect now that as this time frame closes, they're going to see a lot more of that stuff, and where they might have been more willing to take a pass on it before because it had that intervening parent-child transfer. Who knows where they're going to go with it now, and whether or not they're even going to grab stuff that was from a long time ago. If they say there's a corporate trustee and the corporate trustee is not prepared to distribute the home to the child until the estate is ready to close, maybe some 2 years later, can the child still file the claim before receiving the property? What if the corporate trustee is not prepared to allow the child in the house until the estate is ready to close? How can the child protect its claim? That's a good question. I don't know. I mean, the rule says that the child has to file the homeowner's exemption or the disabled veterans exemption claim form within a year, and that requires actually making it the residence. It's not just sort of a prospective thing that they can do because they intend to move in. So this goes to the question of whether or not you can end up getting prospective relief after that. But these are really good questions that I just don't have the answers to. I just don't know. There may be liability for the corporate trustees. Maybe they kind of back off on this stuff. But the homeowner's exemption requires that the claimant to actually have made the home their principal residence. They scan these. With the mom and son own property as joint tenants, mom transfers her interest to son before February 15th. Any problem with this? I mean, no, there's no problem with it. I just think back to my point earlier is that her transfer to her son before February 15th is a nothing. So it's not a change in ownership that would even allow for a parent-child exclusion to be filed because it's creating an other than original transfer in the son. So, oh no, I'm sorry, I misread the question. Mom and son own property is joint. My apologies. Mom and son own property is joint tenancy. Mom transfers her interest to son before February 15th. Any problem with this? No. When two parties own property as joint tenants and they acquired it that way, you're back in what I refer to as in paragraph C on page 10. It's the basic rule that if there are no other original transfers or other than original transfers, that the transfer of either 50% interest is a full change in ownership subject to an exclusion. So if mom transferred her interest to her son before February 15th, that would be a good change in ownership subject to a parent-child exclusion being filed on that. And then let's see, if transfer family home goes to son and daughter in equal shares on transfer's death, and son makes the family home his principal residence, what happens if he later buys out his sister's interest? Is this a transfer 50%? I don't know. This is from Stacy. I don't know. I think this goes to the whole question of what the legislature is going to do with the fractional interests. I mean, it seems to me that it shouldn't be. But I just don't know where they're going to go with this. If the idea is that it becomes the principal residence of one of them, then it should be that nothing happens on the 50% transfer. But then they really are they'd have to eliminate from the basic definition of change in ownership what would normally be, as you and I know, a change in ownership. Let me see if these are how to do these. How do these answered? Scroll down here. Will Prop 19 affect the homes inherited by children through a trust with the settler parent dying before February 16th, but the grantee to the Benny executed after February 16th? So no, William, this is this to the point that I made earlier on, that regardless of when the trust administration is done, that the transfer of property from a decedent who died on or before February 15th is covered by Prop 58 or Prop 193. So it doesn't matter when the grant deed is done. It could be done 5-10 years from now. It could sit in the trust and just be distributed out later. It's always a transfer that is the date of death. And there's really no controversy around that. I've never heard there ever being any controversy around it. The BOE materials cite to that stuff, so I don't think there should be any problem there. I think you do have, I've heard a couple counties saying that they were going to require that Prop 58 claims be in by today, but that's just garbage. I don't know where they were going with that stuff. see, I think I've got all these. Open questions, if there's any more here. 3 kids, 1 moving. Is that okay? Got that. Anyone ask more questions if you want? I think I've gone through these. Step transaction. Will they now attack the step transaction theory? I should note on the step transaction theory, the in and out, what I call the in and out of the entity stuff. There have been a couple tightenings of those in counties up north. San Mateo was restricting the use of those transactions where there were multiple families involved in the ownership. So like 4 brothers that owned a property together and went into an entity, and they each gave half of their partnership or LLC interest to a kid, and they came out and then they each gave a tick interest to their kids. It's really the same formula transaction, but with four brothers. So they're 4 separate nuclear families have been rejected by San Mateo County, and the state backed them up on that. So I suspect that the BOE will come out with some guidance that says that those can't be done. Just by way of history, those transactions have been on the chopping block. We're on the chopping block back when I worked at the BOE many years ago, and then got salvaged. So I suspect that the BOE will come out with some guidance that basically says that you can't do those anymore because they now have a reason to do so. So I don't know. I mean, they're busy. I don't know that they'll do that, but I suspect that if someone wrote them and asked them, that's what they would say. If there's anything else here. Okay, if I have a client with 3 children and assets to be divided equally, is it smart for property tax purposes to always recommend that mom and dad buy any real property in the name of an entity like an LLC, since if the transfer is to the 3 children equal shares, there's unlikely to be a change in control and therefore not likely any future change in ownership? Yes, Ed, that is absolutely the way to advise your clients. Your clients should always be buying property in entities until the entity rules change, just to only be under the change in control rules and not have to deal with the original corner stuff. But again, go back and make sure that you're really clear with your clients as to what what entities are subject to the original corner rules, because there may be some out there that they're not talking about, and there may be some opportunities there to work with stuff that's there and wouldn't cause reassessment that people might think that there would be. Can the legislature change property team? No, they cannot. So the language itself is added to the Constitution. So it added sections 2.1, 2.2, and 2.3. 2.1, 2, and 3 are the provisions that deal with the money. But 2.1 basically is where the provisions that we're talking about are. And this is in the California Constitution. Its language is what you see on the Exhibit A. The legislature can adopt rules that are for purposes of defining things. They can create claim requirement rules. They can expound upon things that just sort of push it a little bit, but the basic rights and privileges there, the way of calculating it are there. I suspect where you'll see rules are around fractional interest shares and that sort of stuff that are just left, vague or unanswered. So I think they'll probably move in a direction of liberalizing it a little bit, and then there'll be litigation in terms of the county saying that you went too far, et cetera, on that. See, how might a trustee find the supplemental tax? This is a good question, Stacey. How might a trustee find the supplemental tax on a property before distributing proceeds of a sale to beneficiaries of the trust, avoiding the potential personal liability that I spoke about? So there will be no supplemental assessment until it's actually done by the county. So you'll have to make sure that the same as you've always done, that the change in ownership, death of real property owner, which I call the DORPO, that the DORPOs are filed. That's the triggering event. Your affidavit, death of trustee being recorded, and your DORPO being filed are the triggering event that there's been a death and a transfer. Obviously, if the affidavit, death of trustee is not necessary because the child's already on title, you got to make sure that the county knows about it. So even if the affidavit of death of trustee is not going to be recorded, you still have to do your DORPO filing so that the assessor knows that there's been a death. If that's not done, like, trustee has a big problem. So get that done and then just get in the queue. Obviously in LA, these things take forever. But then when the supplemental assessment is done, that's when the notice of supplemental assessment goes out. So it's not too long after, it's just kind of like a couple days after they actually finish the work on the valuation for supplemental assessment that it will be enrolled as a supplemental assessment. Go to the LA County's portal. The portal is excellent in LA County. It's the only county in the state that has it. So on the portal, when you put in the APN and you scroll to the bottom to the assessment history and you open up the little plus boxes next to all the assessment history, you can see when a supplemental assessment is being enrolled. And so you can kind of track it there by date. But otherwise, the bill is not going to come out until there's a notice of proposed, and then the notice of, and then the bill sometime thereafter. So there were, many pieces of mail that come out to flag this. But if notices are going to places that are not the trustee's address, that's a problem. All that stuff has to be cleaned up. But to have your clients recognize that there is going to be a property tax bill post-death. They're going to be, and that the longer that the administration goes on and the properties are not sold or distributed, the longer it's going to be. This is interesting too. I see often where beneficiaries get a distribution of the property, and this happens where there's just one beneficiary or two beneficiaries. And then the supplemental assessments are made and they get the bill, but they never got possession of the property for 18 months, 2 years, because it was in the trust and the trust administration, corporate trustees, whatever. And the beneficiaries complain and want to have me do something about it because they're getting this bill. Sorry, the beneficiaries have to pay the bills. For property tax purposes, they're deemed to be the owners. And so the bill is going to be, if it's not sold, it's going to be a secured bill on the property. Trustee does not have personal responsibility for those unless the trustee has sold the property and or otherwise distributed it and not reserved the cash for it. So I think and that maybe sound confusing, but there's personal responsibility for it if the beneficiary doesn't pay it. But ultimately, if it's distributed to a beneficiary, it is a secured bill. It's more a problem where it's been sold and then the funds are distributed and no one's going to do anything about it. So I think it's about doing the diligence to just follow it where it is on the portal to see where it is in the system, whether it gets reassessed. Okay. Chung, see what's you get. Eric asked, let me go back up here. Sorry, these are, sorry, Eric. Back to Eric's work. H and W own a personal residence. H dies, 50% of the residence is allocated to a bypass, 50% survivor's trust, AB. Wife dies after 216. Does H and W as transferors each have $1 million of parent-child exclusion for this two separate undivided interests in the family home? Or are they limited to $500,000 each? I think the answer is that it's only $1 million for the whole property. It's not clear. It's pretty clear to me that it's just meant to be $1 million of value benefit to an entire residence. So whether that's framed as 500 each for husband and wife or just $1 million total, I think that's what it is. I don't see any reading, Eric, of this, that there's a $2 million benefit to the transferee because there were two owners of it. Let's see if there's anything else. Where client through his living trust sells to irrevocable trust, FBO client's children, should we send both trust to the assessor? Client through his trust, yes, as a transfer sells to irrevocable trust, FBO client's children, yes, you should send both to them. If you want to, this is Norman's question, if you want to establish that it transfers from a trust and that the owner of the property in the trust is the parent, and then it's to another trust for the benefit of the children, and you want to have a parent-child transfer, you have to show them both trusts, just to make it clear to the assessor that the beneficiary of the grantor, not the grantor trust, the trust that's making the transfer is for the benefit, sole benefit of the parents. Let's see where else. I think we're gonna, I don't know how fast the legislature is going to do anything about coming up with rules on this stuff. So I guess maybe we'll leave it there. If you guys have any questions, I'm probably signing out for the week. It's been a, I'm sure for you guys all too, it's been a rough, long few months. But I'll try to get to some things if they're short and sweet. And I think that's it. Let me see if there's anything else. Yeah. Looks like I got everything. So take care and we'll see you all later. Thanks.